Welcome, everyone. Mr. Halpern, we see you on the phone, and Ms. Blair, we see you here. We're going to call this case. It is People versus Kabongo. This is a 20-minute grant, and we will start with you, Mr. Halpern. You may reserve time if you want to, but you'll try to manage that yourself.
Yes, I will. Thank you.
And you may proceed whenever you're
ready. Good morning. I'm ready. Thank you. Justices, this case has two issues, and they both involve the 14th Amendment, equal protection. The issue here has to do with peremptory challenges, in challenge both ways. And the nature of the objections here, I believe, require the application of the federal law and Batson and his progeny. The defense challenged the prosecutor's challenge to juror number 2, who is an African American. There's no question that the first two steps of Batson were readily stated. The objection was based on racial discrimination, and a statement of reasons were provided. And then the court gets involved, obviously, in terms of scrutinizing the reasons given. And what happens here is that the analysis of the reasons given with the actual record is absolutely baseless when you take it one at a time. The claims that the prosecution made in the step number 2 were that juror number 2 had a short memory problems. There wasn't an iota of a short-term memory problem whatsoever. It was never inquired into, and it was never demonstrated. The prospective juror herself remembered, in fact, the first question. When asked about her occupation, she replied, retired, stating that she couldn't remember answers to the questions was not accurate. She answered quickly and promptly all questions. If you look and then a comparative, which is probably pretty important too, to look at comparative questions to jurors. Juror number 13, who was white and advanced years. I prefer that statement rather than old or elderly, and indicated retired. However, the prosecutor in no way whatsoever asked any questions pertaining to his memory concerns. The statement that juror number 2 should not have been removed as a juror violated the 14th Amendment, equal protection. The court removed number 2, denying the defense's a challenge to it. And a Batson error clearly has occurred when a juror is dismissed on the basis of race. There is no basis whatsoever, factually. And I want to get to something else about the judge's rulings as well.
Mr. Halpern, do you mind? I'm going to interrupt you and see if my colleagues have questions first, and then we'll come back to you because you'll have some more time, okay?
Thank you. Sure.
Take my word for it. I'm going to go through and this will work out, I promise. We're going to start with Justice Viviano.
Good morning, Mr. Halpern. I do not have any questions for you at this time. Thank you.
Justice Bernstein.
Counsel, good morning. Welcome to the Supreme Court. I just want to let you know that, the technical difficulties that you're experiencing where you're doing this by phone, I do this every day, so I totally understand and completely empathize with, what you're having to experience right now. So don't worry about it.
All right. Thank you. Thank you. Thank you. Thank you.
That was an easy question. Justice
Yeah.
Clement,
Anybody else?
No
Yeah.
questions, thank you.
Justice Cavanagh,
I don't have any questions.
Justice Markman,
Thank you.
Justice Zahra.
Okay, I'll bite. Mr. Halpern, you indicated when a juror is dismissed because of race, it's a wrongful thing. I agree. I guess the question is, how do we come to that conclusion? I understand your argument, and I think it's got some, it's well-founded and has some merit that there was really no question of short-term memory. But is that enough then to conclude it must have been on the basis of race? When I look at all the interactions with juror number two said in this open carry case that if I'm confronted with someone who's carrying a gun, yeah, I'm not going to like that. I'd be intimidated. As a matter of fact, I think the exact language, and it might have been in response to your question when asked about open carry, and you said yes. Potential juror number two said it would depend on where I'm at. If I'm in a bank and somebody came in with a gun, I would be concerned. I would depend on where I'm at. If somebody's walking around with a gun, yeah, I'm feeling threatened. Isn't that an indication that perhaps someone exercising their Second Amendment rights is going to cause this person to be uncomfortable? And in an open carry case, perhaps they aren't the best juror to have on the panel for the prosecution?
For the prosecution? No, I would say just about the opposite. It sounds to me like the prosecutor would. I doubt that the prosecutor would want to do that. It makes the prosecutor's case. There's absolutely. It would be a reason for my challenge.
Yeah, I get that. Okay, I get that, but still, I understand that, but still, a prosecutor, they're if they have concern that someone's not going to follow the law, wouldn't that be a reason? Let's go back though, even before that. It seems to me that when there was questioning about whether you've ever been a victim to the crime, they also said, I've been a victim of robbery and stuff like that, but it's been a long time. Should the prosecutor be concerned about an unwillingness to open up about the robbery, or is it on the prosecution to question more?
I don't mean to avoid Your Honor's question, but the fact is, this wasn't even mentioned sideways.
Oh, I get that. I get that. And I guess my question to you, does that matter? Is it enough if we agree with you that, short-term memory really wasn't an issue, perhaps long-term memory, but short-term, is that enough to then conclude that it must have been on the basis of race? That's the question.
Well, that's the question. The question is there a race or whatever, a free reason for it? The only reasons given, as I mentioned without repetition, were inaccurate. They were not factually based at all. None. And if there was any, Your Honor is suggesting there might be some reasons. I see no reason why the prosecutor would not want to state them. But that was not her reasons. Her reasons were stated. Your Honor's reasons, may have been a basis for it. They weren't hers.
I get that. And I guess it's in my view, it's pretty substantial that you'd essentially accuse a prosecutor of making a determination on the basis of race. Do we make that determination merely because we conclude that when asked, why did you do this? And they say, well, I had concerns about short-term memory. And we look at the record, we don't really see concerns about short-term memory, but we do see some references to memory, how things occurred a long time ago. Do we have any latitude in saying, well, let's dig in a little deeper, or is it as a matter of law, does it require us to conclude it must have been on race because there isn't an issue of short-term memory here?
I believe that regardless of what the courts can come up with as a basis for a peremptory challenge, and an indication that possibly that there was some basis other than race, is hard to say this, but is irrelevant to the issue of the statements and basis that the prosecutor tendered.
So if we conclude that the claim of short-term memory isn't founded, we must conclude it was then that the challenge was on the basis of race.
Yeah. One of the things I asked was a question that was really convoluted, which I probably do too much. And this is a person who repeated, clarified, or whatever the question. There was nothing about this person that fit any of the objections, any of the bases that the prosecutor stated. Zero. If there was any basis for it, it wasn't the ones that were stated. And that's all that matters.
All right, let's switch to juror number 5 and the court's denial of giving you the opportunity to remove juror number 5. Did you not kind of set that up when you responded at one point? Prosecutor said, with regard to Batson, Your Honor, for the record, 2 jurors that defense counsel has excused have both been Caucasian. I did make note of that. I'm not raising a Batson challenge at this time, but I want the court to be on notice that a potential issue may be coming up. And your response was, well, in terms of potential issue, let's see how many more Black people the prosecutor excuses. Aren't you suggesting that you're going to dismiss a juror on the basis of being white in response to any further dismissal by the prosecutor on the of a juror who happens to be Black?
No. The short answer, I'm sorry, not at all. It's even difficult for me to catch up to what Your Honor is stating, because I didn't mean that at all.
Well, your words I'm taking from the record were, well, in terms of potential issues, let's see how many more Black people the prosecutor excuses.
Yes, because I was aware, in fact, the prosecutor excused another Black person who is not, I can't think of his number, but it's not part of this record. So my experience of 61 years is that prosecutors do this all the time. It's a rare occasion that an attorney representing a Black defendant is trying to get rid of white jurors. I said that solely. I realize your interpretation, but I made that statement solely to put the court on notice, just as the prosecutor has put the court on some kind of notice that I was going to excuse white people. That was the only basis that I said. Be on the lookout.
I see. Okay, thank you.
About juror number 4, may I go on with juror number 5?
You may. You have 6 minutes left.
Juror number 5. This was a challenge with regard to juror number 5. The first 2 steps of Batson, of course, were there. There was no question about it. And juror number 5, the defense then offered strategic reasons in terms of step number 2. Close association of law enforcement, a lack of commitment to be fair. It was very clear when a direct question, and there was also an issue lingering issue, I suppose, about whether or not there was a prior felony conviction. And all three reasons were factually accurate, and they were based on what I would call an accepted trial strategy. The trial court, I submit, was objectively unreasonable in applying Batson. This good faith statement that was made by the prosecutor, I think, misapplied. But this was clear in terms of good faith of the court itself. The reasons that I advanced were okay. I mean, okay, they were accepted trial strategies, and they were clearly stated and clearly justifiable. And the idea of a case involving weighing a law enforcement officer's testimony with a defendant and civilian testimony comes up all the time. It's a legitimate strategy to remove jurors who may, in fact, have a pro-law enforcement associations, and this juror certainly did. Born, raised, continuing to live with law enforcement officers, generations of law enforcement officers, and by marriage. It just seems so obvious, and yet I submit the court was grossly derelict in its duty to scrutinize, and I believe that indicated bad faith in applying Batson. The result of it crosses a denial of due process and certainly undermines the result and requires reversal. There was not again, using an oft-used iota word, not an iota whatsoever of an indication of a lack of a basis for the challenge itself. The challenge was absolutely justified, certainly as a peremptory challenge, and probably, if developed necessarily, if I had wanted to, readily would be a basis for a challenge for cause as well. I have no doubt from my experience that with that kind of a background, the questions that I could frame
Mr. Halpern, I think Justice Zahra have another question.
Yes.
Mr. Halpern, I understand your argument. I understand you had some reasons to articulate that were not race related for excusing juror number 5. But what if the court interpreted your comment the way I did? In fact, the record supports that conclusion, and perhaps that's what led me to my understanding of your remark, because the prosecution objects or puts the court on notice that you've been excusing white jurors, to which you respond, well, in terms of political issues, let's see how many more black people the prosecutor excuses in response to the prosecution's claim that you may be excusing too many white people. And the court admonished you. The court said, Mr. Halpern, we don't need that. That's an unnecessary remark. So if the court is now faced with, here are these non-race-based reasons, but you made a remark in court that the judge believes you're stating, I'm going to dismiss a white person for every black person dismissed. Is it outside the range of reasonable outcomes? Is it an abuse of discretion here for the court to say, I'm not going to let you take number 5 off in light of your comment?
Well, I note as well that the court never in any manner at all admonished the prosecutor for making a statement about removal of people that she said were prospective jurors that she indicated be on the lookout.
But you're dodging the question as to for juror number 5 right now.
Regardless of judge still has this group. Look, no matter what the judge feels, in terms of, I don't like this guy. I get a lot of that, actually. But I'm not running for anything. And the fact of the matter is that I've given bases for my exercise of a peremptory. I've given valid bases and factually based bases. And to somehow circumvent that and say, I don't like this guy.
All right, I understand your argument. I'm not sure that's what the trial court said, but I understand your argument. Thank you.
Mr. Halpern, thank you. You are out of time. Ms. Blair, you may proceed.
May it please the court,
Okay.
Deborah Blair, on behalf of the people, the Wayne County Prosecutor's Office, the appellee in this matter. The court has asked the parties to address 4 issues in this case. The first is whether the prosecutor's peremptory challenge of juror number 2 violated Batson versus Kentucky. This issue is a purely factual determination, and since the trial court was in a much better position to make these factual determinations, its decision should stand. The second issue is whether the trial court made a mistake as to the defendant's peremptory challenge of juror number 5. This also is a factual determination, and looking at the record, due deference must be given to the trial court's findings of fact in this regard. Therefore, juror number 5 was properly left on the jury to deliberate. The third question is, if the trial court did make a mistake as to defendant's peremptory challenge of juror number 5, should this mistake be treated as harmless error or under structural constitutional error? And finally, whether reversal is required in this case. The people do not believe that reversal is required in this case. The third issue is probably the most important for future cases. This issue can be rephrased as where there is a reverse Batson challenge, that is where the prosecutor challenges a peremptory challenge made by the defendant, and the trial court makes a mistake and finds discriminatory intent where there was none, thus depriving the defendant of a peremptory challenge he otherwise would enjoy. Can this error be subject to harmless error analysis? The answer in Michigan since at least 2005 in People versus Bell has been yes, this can be treated as harmless error. Courts have been following this reasoning for 15 years without an issue. The reason for that is even where a juror is allowed to remain on the jury that is not of the defendant's liking, as long as the juror is qualified and can be fair, no harm has befallen the defendant by a denial of a peremptory challenge. The reliability of the verdict has not been undermined. It would be the same as if no peremptory challenges were allowed to either side, which is constitutionally permitted. It simply does not rise to a constitutional deprivation. A defendant is entitled to a fair trial, not a perfect one. And the fact that a juror may not be the defendant's favorite, purportedly in this case because she had family members in law enforcement, is allowed to sit on the jury and deliberate, does not transform the trial into one that is fundamentally unfair. To rule otherwise would presumably require that the defendant would be entitled to unlimited peremptory challenges until an ideal or perfect jury could be impaneled. Obviously, both functionally and legally, this is not required. There will always be times where a juror remains on the panel that is not of the defendant's liking simply because the defendant has exhausted his peremptory challenges. That does not rise to the level of structural error. In conclusion, the people respectfully request that this honorable court find no error occurred in this case, but if there is one, it was harmless, and affirm the defendant's conviction and sentence. Thank you.
Thank you, Ms. Blair. Justice Viviano?
No questions. Thank you.
Justice Bernstein?
Yes, Counselor, good morning. I just have a few questions for you. I wonder if you could help me kind of sort through it. Was there anything, in terms of the questions that juror was asked to add, juror number 2, basically the issue as it pertained to, she had indicated she has a senior moment. The judge said that, he wasn't far behind. And the questions that were asked, when you look at it, it's a lot of anxiety. It's you're in a courtroom, the people are nervous, there's a little bit of tension. Some people are just anxious. And the questions that were being asked, I think a lot of people might have had a hard time stumbling. They might have stumbled on some of those questions. Has anyone in your family ever been the victim of a crime? People don't necessarily know that right offhand. So, I mean, I guess my question would be is that, do you give any credence to the issue? And I think Justice Zahra asked some very good questions, as it pertained to that, but I just want to kind of take it from a different perspective. Was there anything out of the ordinary as it pertained to this juror's memory or comprehension that involved dismissal?
Well, first, I would point out that the prosecutor can be wrong in her peremptory challenge. She could be mistaken. That does not mean that she was using race as a factor. She was just simply wrong. And in this case, I don't think she was wrong, because if you look at, and it's hard to just point this out from a cold record. But I believe that the juror, when asked about her level of education, the first question had to be prompted as to her education and her occupation. She says, "I'm retired." And then the court has to prompt her, "Retired from what?" "Counseling." "Okay." And then the juror says, "I was a counselor and then I retired." So there's a little bit of prompting there, I believe.
I mean, no, I hear what you're saying, but I'm just trying to, and I think I get your argument though, and I respect it. I'm just trying to gather it a little bit. But I mean, I guess because it's just, if you look at the flow of normal conversation, if you look at voir dire, if you look at the setting that citizens are in when they're in that circumstance, I mean, do you really feel that's prompting if you say, "What was your profession?" "I'm retired." It doesn't mean you don't know what your profession is, or it doesn't mean that you're confused as to your profession is. It just means that you're kind of answering the question, right? Like, what's your profession? "I'm retired." Does that really go to that person's memory? I guess my question is that, do you see how someone could have some concern about this?
Well, maybe, but if in different circumstances you didn't already know that the prosecutor left 3 African Americans, a Hispanic person, and an Arabic person to remain on the jury, and that the first thing that the second thing that the juror mentions is, "I have seen your moments," the prosecutor is allowed to take that into account. As long as she doesn't use race.
No, I understand. And I'm not trying to give you a hard time. I'm just trying to gather all this. But then the judge kind of it was kind of more of a conversation. And the judge kind of said, "Hey, I'm right behind you." I mean, okay, but please go on. I don't mean to cut you off.
No, I was just gonna mention that the prosecutor is allowed to be wrong. Perhaps this person didn't have memory problems, but that's a peremptory challenge. It doesn't have to rise to a level of cause. It doesn't have to be absolutely true. It's a peremptory challenge. And there's nothing in this record that shows that this prosecutor was using race as a factor in her jury selection.
Okay, I just have one more question then. Based on that, how do I know what the balance is though? I mean, if a prosecutor can be wrong, and of course they can be wrong, but how do I balance that with maybe a concern that arises out of bad sense? So what would the balance test be? How would I, if I'm writing an opinion, how would I do that? How would I balance it out?
Well, each side has an issue, or has an interest in having a fair jury, both the defense and the prosecution. But as long as the juror says that she is qualified, and this juror was qualified, and as long as she can be fair, and this juror stated she can be fair, there is no constitutional deprivation. The defendant has a fair trial.
Okay, I see your argument. Thank you, counsel.
Justice Clement?
No questions. Thank you.
Justice Cavanagh?
I have a question. I understand the argument, and I think that you've made that automatic reversal, assuming that we find error in the reverse Batson challenge of juror number 5, that automatic reversals could sort of load the dice against the prosecution. But I think the argument can also be made that harmless error sort of loads the dice against the defendant. How can you give me sort of an example or a couple examples or a theory of how it is that a defendant is going to be able to show that a reverse Batson error is not harmless?
The only situation that I could assume is where a judge has not gone through the 3-step process, does not use a good faith attempt to explore the issue, or the judge makes a decision, purely on something not based in the record or not based on fact. In that situation, I would say absolutely, defendant, you didn't get a fair trial because the judge was being arbitrary and capricious against you. But we don't have that here.
Well, I think my question, let's assume that we've already determined that there is a reverse Batson error. We've already determined that the challenge, that the judge's decision was wrong. How would a defendant still prove that despite that error, or how would the defendant prove that the error wasn't harmless?
The defendant would have to show that the juror was not qualified to sit on the jury, or that the juror could not possibly be fair. In those situations, then the defendant would be entitled to a new trial.
Okay, thank you.
Following up on that, Ms. Blair, can you give me an example of a circumstance where a defendant could show prejudice from the denial of a peremptory challenge when the juror was not also removable for cause? Because I think your answer to Justice Cavanagh, the juror would have been removable for cause. And I'm just trying to come up with an example of how a defendant could show prejudice when that wasn't also the case.
Well, if the pattern of removal was extreme, then that would be cogent evidence that the prosecutor was using a pattern of discrimination. That would be similar to the situation in Flowers versus Mississippi, United States Supreme Court in 2019, where the prosecutor removed all the African-American jury members from the panel. And
6 trials in a row, apparently, from my reading of the case. Yeah.
And the Supreme Court said, yes, this is more than just a prima facie case of discrimination. You removed every Black juror that you could.
So that's the only way a defendant can show prejudice, if like 6 trials in a row, the prosecutor removes all the African-American jurors?
That would be an extreme example, but that's certainly one that I'm aware of.
Okay. Justice Markman?
Yes, I've got a question as well. You responded to a question that was raised to you several moments ago, Ms. Blair, that was raised by Justice Bernstein, and I'd like to probe that just a little bit further, if I might. Given that we're talking about a Batson error, which is grounded in a constitutional basis, the 14th Amendment Equal Protection Clause, a Batson claim is, in other words, a constitutional issue. We necessarily, I think, are addressing a question of purposeful discrimination. The Constitution generally requires purposeful, not statistical or effects-based discrimination. So I'd like to ask you, what if an appellate judge, and you've got several in the room here now, is not ultimately persuaded by the prosecutor's assertion of a non-discriminatory ground for his challenge, but nonetheless that this court believes that the objections were sincerely and honestly taken? Must we not still characterize the challenge as an exercise in purposeful discrimination? You say something to the effect that a prosecutor is merely wrong in his explanation, is not necessarily acting in violation of Batson. I'm not sure that's right. Is that really so? I mean, isn't inadequacy of a non-racial justification, in fact, exactly tantamount to a 14th Amendment violation in the context of Batson? In other words, if we're not persuaded by what the prosecutor said in this case, that is a violation of the Constitution, notwithstanding apparently that we might not all be persuaded that it was a purposeful exercise in discrimination. What is the law here precisely?
Well, in Hernandez versus United States, the prosecutor's purported reason for removing 2 Hispanic members of the jury was that he was not convinced that they would faithfully adhere to the official translation of the record. And that is so subjective. How would you know that? You don't know that. But the United States Supreme Court says that's okay. He can make a mistake on that. Maybe he's wrong. Maybe they would adhere to the official translation of the record, but that is not discrimination. So under Hernandez versus New York, I believe you can be wrong and still not be racially prejudiced.
So ultimately, there's no obligation on the part of the prosecutor when challenged to justify his challenges by asserting persuasive non-racial justification for having engaged in those challenges.
No, he absolutely should be persuasive, but you have to look at the entire record. You have to look at the entire subject of the challenge. And in this situation, looking the entirety of the situation, it cannot be concluded that the prosecutor was being vindictive or trying to be racially excluding of African-American jurors. That just simply did not occur.
But I asked you what the members of this court should do under these circumstances. If after each of the 7 of us look at the entirety of the record and we're not persuaded that the explanation is one that satisfies a non-racial basis for the challenges, but nonetheless that he wasn't animated by discriminatory purpose or intention, don't we still have to find that Batson has been satisfied under those circumstances?
No, because the standard of review is clear error and gives great deference to the trial court's finding of fact. Because as you say,
well, I understand we give great deference to the trial court, but once we've given that great deference and we're nonetheless persuaded that the trial court erred, which is, I think, the issue before us now, what do we do under the circumstances I've just explained?
Well, if you find clear error and you find that there was intentional discrimination, you have to give the defendant a new trial. I mean, that's Batson versus Kentucky.
Even if we believe that he wasn't acting in a purposefully discriminatory fashion.
Well, if you don't believe there's any discrimination, there's no violation of Batson. I mean, Batson only goes to a discriminatory intent. That's the only reason Batson exists.
Thank you, counsel.
Justice Zahra?
What was the case you cited that said the prosecutor can be wrong and you were referred to interpreters?
Hernandez versus New York, 500 U.S. 352, 1991.
Okay, isn't there a big distinction between that case and this case? There, the prosecutor was merely speculating. There's going to be interpreters here, and I have a fear that they won't follow the interpretation because they're so good in the way they speak language. That seems to be a non-racial reason, non-ethnic reason, whatever. It is a reason, it's speculation. They may be wrong. I think that's the holding there. Where here, there's a citation to a fact. The jurors showed poor short-term memory. When we look at the record, we don't see that. Perhaps we see some long-term memory. Perhaps we see some unwillingness by the juror to speak. But to me, it's an objective, verifiable fact that proves to be wrong. Why isn't this a valid distinction from Hernandez?
I don't think that the memory can be a verifiable fact on this short of a record. I mean, you're always making judgment calls.
Well, slow down. Do you agree that the articulated reason was poor short-term memory?
Yes.
Where is there anything about short-term memory in here?
Well, as I pointed out, she had to be prompted when she was first addressed by the court after She said that she was retired. And then the second thing out of her mouth was senior moments. I mean, why isn't the prosecutor allowed to rely on that? It's only a peremptory challenge. She doesn't have to be right. She can be wrong.
All right. I would say that the prosecutor could have made a better record. You'd agree with that, right? But your response would be they don't have to make the best record. They just have to give a reason.
Right. And then you have to look at what the defense's prima facie case wasn't even correct when he started. He said he couldn't remember whether it was 3 challenges or 4 challenges. He didn't even have the number of peremptory challenges correct. So to say there was clear error in that case, I just don't see it.
Okay. And all the environmental concerns raised by Justice Bernstein, people are nervous. They might not be comfortable in a courtroom. Isn't this exactly why we defer to the trial judge who has the opportunity to observe these things and make a determination whether this is mere nervousness or perhaps something more relating to this juror's ability to follow the evidence?
Absolutely. And that's what happened in this case.
All right. And one more easy question for you. In response to Justice Cavanagh, isn't it fair to say that that we should apply a harmless error analysis because there is no absolute right to a peremptory challenge? It's something that's there by grace. There's no constitutional right to it. So when you're denied it, you still have the burden of showing that the error was harmful as opposed to raising what is not a constitutional right to the level of a structural error.
That's correct, especially in light of MCL 769.26, which is the statute that requires the error complained of must result in a miscarriage of justice, which cannot be shown in this case.
Okay. Is it fair to say that the prosecution perhaps failed to articulate that the concern about memory was really this juror doesn't seem to be comfortable giving information? For example, you had to pull out that they were a victim of a robbery and couldn't remember when. It would seem to me that'd be a pretty significant life event that you'd remember.
Right, that would have made a better record, but Hernandez says that the second step does not require a pervasive or even plausible explanation by the prosecutor. As long as the reason is not inherently discriminatory, the reason offered is race neutral.
And I guess this takes me to the point Justice Markman was making here. Can we look at the record and massage the reasons and say this is a good peremptory? After all, it's not for cause. It's just I see reasons for peremptory. Or do we take on its face what the prosecution said, i.e., short-term memory, and if we see nothing more than some reference to a senior moment that appeared to be light in passing between the judge and the juror, that's not enough? We must then therefore conclude that it is racial discrimination.
No, I think you couldn't. I mean, that would give such a chilling effect to prosecutors. I mean, that would invade the whole process of jury selection. The whole point of peremptory selection is peremptory challenges is you can remove them for any reason at all, as long as it's not based on race.
Well, why is it chilling when you know Batson is out there? Wouldn't that give you reason to fully and completely articulate your basis for the challenge? Wouldn't chill, it would inspire me to say more.
Well, it could, or it could create a situation where, race is always a factor, and there's Batson challenges every time a person of one race or the other is removed.
Okay, thank you very much.
You should have a good basis in fact before you make a Batson challenge.
Thank you, Ms. Blair. Thank you, Mr. Halpern. You both have used up your time and then some, and the case will be submitted. Thank you very much.